Welcome to episode 39 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name's Bailey, and I'll be reading the Supreme Court's opinion in District of Columbia versus RW. This case was decided April 20th, 2026. And there is no syllabus, so we'll move on to the opinion, which was written per curiam. In the wee hours of a winter morning in Washington, D.C., District of Columbia Metropolitan Police Officer Clifford Vanderpool received a radio dispatch call directing him to check out a suspicious vehicle at a specific address. Officer Vanderpool reached the apartment building at that address around 2 a.m. As he turned his marked police vehicle into the parking lot, he saw two people immediately flee from a car unprovoked after police had not done anything other than simply pull up. The runners left open at least one of their car doors. The driver then began to back out of the parking space, rear door still open. Officer Vanderpool decided to investigate. He parked directly behind the car, left his own vehicle, ordered the driver RW to put his hands up, and drew his service weapon. RW raised a single argument on appeal that Officer Vanderpool lacked reasonable articulable suspicion sufficient to justify the seizure. The District of Columbia Court of Appeals held that Officer Vanderpool, by stopping RW without reasonable suspicion, violated the Fourth Amendment. We disagree. When an officer makes a brief investigatory stop of persons or vehicles that falls short of a traditional arrest, the Fourth Amendment is satisfied if the officer's action is supported by reasonable suspicion to believe that criminal activity may be afoot. In assessing whether an officer had reasonable suspicion, a reviewing court must look at the totality of the circumstances of each case, an analysis that precludes the evaluation and rejection of factors in isolation from each other. Because the D.C. Court of Appeals departed from these principles, and because Officer Vanderpool clearly had reasonable suspicion to stop RW, we reverse. Part 1. Largely based on evidence found after Officer Vanderpool told RW to put his hands up, the District of Columbia charged RW, a minor at the time, with unauthorized use of a motor vehicle, felony receipt of stolen property, unlawful entry of a motor vehicle, and operating a vehicle in the District of Columbia without a permit. Before trial, RW moved to suppress the evidence obtained after he was stopped. Following a suppression hearing, the trial court denied RW's motion, relying on four facts to conclude that the officer had reasonable suspicion to stop RW. 1. The officer had received a radio dispatch call regarding a suspicious vehicle at a specified address. 2. The officer saw two persons fleeing from a vehicle upon his arrival. 3. It was almost 2 a.m. And 4. As the officer approached the car, it began backing out of the parking space while the rear driver's side door was still open. After a bench trial, the trial court adjudicated RW delinquent on all counts and assigned RW 1 year of probation with conditions. On appeal, the D.C. Court of Appeals reversed the denial of the motion to suppress and vacated the delinquency adjudication. Footnote 1. The District of Columbia conceded that Officer Vanderpool seized RW when he first asked RW to put his hands up, so the D.C. Court of Appeals decided only whether the facts then known by Officer Vanderpool created an objectively reasonable suspicion that criminal activity was afoot. Carrying on. The court first assessed the legitimacy and weight of each of the factors bearing on reasonable suspicion before weighing that information altogether. In the first step of this analysis, it held that the trial court had erred by considering two factors, the radio dispatch call and the flight of RW's companion. It excised those factors from the analysis. It then concluded that without more, the remaining facts, the late hour and the car's movement, did not give rise to reasonable suspicion. After the D.C. Court of Appeals ruled, the District of Columbia sought certiorari. Part 2. The question is whether the facts available to Officer Vanderpool before he ordered RW to put his hands up warranted the stop. In other words, we ask whether Officer Vanderpool had a reasonable suspicion that RW was engaged in criminal wrongdoing. Such reasonable suspicion arises when, based on the totality of the circumstances, the detaining officer had a particularized and objective basis for suspecting criminal wrongdoing. Reasonable suspicion depends on the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. It permits officers to make common sense judgments and inferences about human behavior. On the facts of this case, Officer Vanderpool clearly had reasonable suspicion to stop RW. Already on alert from the late night dispatch call about a suspicious vehicle, the officer observed every person in RW's car respond strangely to an approaching police car. Two people took off running. We have observed that unprovoked flight upon noticing the police is clearly suggestive of wrongdoing. The driver, RW, did not run from the car, but his companion's flight cast his presence in a suspicious light. After all, we have observed that a car passenger will often be engaged in a common enterprise with the driver and have the same interest in concealing the fruits or the evidence of their wrongdoing. We need not determine whether that connection alone supported reasonable suspicion because RW was in the driver's seat and, after the passengers fled from the car, began backing out of the parking space, ignoring the car's open back door. For most drivers, it would be a surprising event for their backseat passengers to exit the car and run headlong away from them. We doubt that most would respond by putting their car into reverse and attempting to drive away without at least checking whether the doors were closed. RW's own actions, combined with the panicked flight of his companions, strongly suggests that he was, like them, engaged in unlawful conduct he wished to hide from police. Part 3. The D.C. Court of Appeals reached a different conclusion by excising the radio dispatch and the conduct of RW's companions from the analysis and considering only the lateness of the hour and the slight movement of the car. The totality of the circumstances test, however, precludes this sort of divide and conquer analysis. As our precedents have recognized, the whole is often greater than the sum of its parts, especially when the parts are viewed in isolation. Indeed, this case reveals the perils of reviewing facts piecemeal and without context. Take the passenger's flight from the car. We have little doubt that, in some circumstances, an officer could not reasonably attribute his suspicion of a fleeing individual to bystanders milling nearby. But the whole picture here tells a different story. After watching two people flee from a suspicious car, a reasonable officer surely would question the driver's next move. Why would the driver hurriedly back up the car without even closing a door left open by his fleeing companions? Perhaps one could imagine an innocent explanation for such unusual behavior. The court below, for example, surmised that RW may not even have noticed that his companions left the door open. But we have consistently recognized that reasonable suspicion need not rule out the possibility of innocent conduct. Based on everything the officer observed on the night in question, he drew the common sense inference that all three people in the car, including the driver, were trying to hide wrongdoing from the police. The Fourth Amendment requires that a court slosh its way through a fact-bound morass. There may be no easy-to-apply legal test or on-off switch in this context, but one thing is clear: the totality of the circumstances requires courts to consider the whole picture. The D.C. Court of Appeals expressly declined to do that. It instead considered only the observations that 1. It was 2 a.m., and 2. RW reversed a few feet in a parking spot while the vehicle's rear door was open. Expressly excised from its analysis was, for example, the compelling fact that two individuals fled the vehicle as soon as they spotted the police car. Pretending that the most revealing aspect of the encounter did not happen is incompatible with the totality of the circumstances approach required by our precedents. The petition for certiorari and RW's motion to proceed in forma pauperis are granted, the judgment of the District of Columbia Court of Appeals is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. It is so ordered. Justice Sotomayor would deny the petition for a writ of certiorari. Justice Jackson dissenting. The Fourth Amendment may require courts to slosh through a fact-bound morass. It does not require readers of judicial opinions to do the same. Any reasonable analysis will, of necessity, tick through factors, finding some weighty, others less so, and still others not at all, before piling them on a scale and assessing the result. That is what the court below did here, and it was right to do so. Announcing a conclusion without providing reasoning along the way is not helpful to the parties, the public, or the development of the law. To its credit, the court applies a similar factor by factor approach here. That the court's analysis is comprehensible shows as much. Like the court below, the per curiam takes account of the facts in turn: a late night dispatch call about a suspicious vehicle, RW's companion's unprovoked flight, RW's shift into reverse with a car door still ajar. And like the court below, the per curiam explains how much weight it assigns to each. Unprovoked flight, the court says, is certainly suggestive of wrongdoing. Combined with the flight, the court continues, RW's abrupt reversal strongly suggested wrongdoing. This is how courts write opinions. So I'm not sure why our court sees fit to intervene in this case, let alone do so summarily. If the intervention reflects a worry that the District of Columbia Court of Appeals, DCCA, misunderstands the Fourth Amendment's totality of the circumstances analysis, that worry seems unfounded. The DCCA has grasped the correct inquiry. Its precedents rightly observe that the issue is not whether any one factor individually justifies a stop, but rather whether collectively the totality of the circumstances supports a determination that the officers had reasonable suspicion for an investigatory stop. If today's decision instead reflects dissatisfaction with the DCCA's comment that it excised certain factors from its analysis, I do not contest that this was poor word choice. But I do not think that word choice reflects a methodological error. Courts excise facts from their analyses every day. Opinion writing is an exercise in culling the irrelevant. In application, no totality of the circumstances test really lives up to its name. Indeed, today's per curiam necessarily omits a number of facts the court finds insignificant. For example, the make and model of the car, the precise location of the stop, the color of RW's friend's clothing. Though it does not say so, the court excises those facts too. It does not thereby misapply the Fourth Amendment. If, finally, the court's decision to intervene reflects disapproval of the DCCA's assessment of which particular facts to weigh and to what extent, I cannot fathom why that kind of fact-bound determination warranted correction by this court. The DCCA assigned no weight to two facts: the dispatch call and the unprovoked flight. The court does not seem to take issue with the first, for good reason. The DCCA reasonably applied our decisions explaining that an officer may not obtain reasonable suspicion by relying on the unsupported hunch of a fellow officer. The court may be right that the second, the unprovoked flight, should have borne some rather than no weight, but if this context-specific adjustment is all the per curiam seeks to achieve, it does not merit the use of our summary discretion. Even if I would have assigned more heft to a particular fact in my own first instance assessment, I would not wordsmith a lower court in this fashion. In my view, this is not a worthy accomplishment for the unusual step of summary reversal. Therefore, I respectfully dissent. And that does it for the opinions of the justices, so we'll get into the opinions of the host. So to start off, obviously this is a very short, kind of straightforward, quote-unquote boring one. The question is just basically, did the DCCA, the District of Columbia Court of Appeals, apply the totality of the circumstances standard or analysis or whatever to this case as it's supposed to under the Fourth Amendment? Because all that the officer needs under the Fourth Amendment to sustain this stop is reasonable suspicion. Whether the officer had reasonable suspicion is assessed according to the totality of the circumstances, meaning you have to look at all relevant circumstances in conjunction with each other. You can't isolate some out and say, well, this wasn't enough for reasonable suspicion, and this wasn't enough for reasonable suspicion, and, so on down the line, for each factor in isolation. You have to look at all of them. And reasonable suspicion, it's a low standard. It's, just what would a reasonable person think given the totality of the circumstances? And the court says sort of 7-2, depending on how you want to look at it, either 7-2 or like 7-1 almost. No, the DCCA did not do the analysis right, so reversed. And, I say it's, 7-2 or 7-1, depending on how you look at it, because Sotomayor just wouldn't have granted the writ of certiorari at all. She wouldn't have granted review in this case at all. Whether that's because she thinks the DCCA got it right, or just because, this isn't appropriate for like a summary reversal or whatever, we don't know. She doesn't say, she doesn't, join any of the opinions. She doesn't write her own opinion. She just wouldn't have granted the writ of certiorari. And Jackson explicitly dissents, whereas obviously the other 7 justices join the per curiam. And the per curiam says, yeah, no, the DCCA didn't do the analysis right. They explicitly, they said they were doing this in their opinion, that they ignored certain factors. They, quote unquote, excised certain factors from the analysis and only looked at a couple of relevant factors, sort of in isolation. And that's wrong. You're not looking at the totality of the circumstances, because you're literally not looking at all of the circumstances, right? It's that simple. And yeah, I think the court is right when you're identifying relevant circumstances, right? Circumstances that are relevant enough that you refer to them explicitly, and you say these are relevant enough that we are passing judgment on what to make of them. You don't just get to ignore them. You don't get to, quote unquote, excise them from the analysis. And, Jackson says in her dissent, well, courts, quote unquote, excise factors all the time because, you can't look at literally the totality of the circumstances because a lot of circumstances are just irrelevant. And so courts just ignore them and, kind of implicitly, quote unquote, excise those factors. Like she says, oh, the court today in the per curiam didn't talk at all about like the color of clothing that the companions were wearing or the make and model of the car or anything like that. It excises those factors from its analysis, sort of implicitly by not considering them at all. And I think that's just wrong. I mean, like, because that's not what the DC Court of Appeals did. It didn't, just completely ignore certain factors as irrelevant. It explicitly passed judgment on what to make of certain factors that any, I think, reasonable person would say these are relevant, and said, we're ignoring them. So it's not just this like, oh, they're not talking about completely irrelevant factors, completely irrelevant circumstances. No, they are identifying relevant circumstances and ignoring them. And you don't get to do that in a totality of the circumstances analysis. So I don't know. I think Jackson is kind of trying to reframe what the DC Court of Appeals did to try and salvage its analysis and its conclusion under the Supreme Court's precedents, under the totality of the circumstances analysis that it's required to do. And yeah, it just strikes me as like just playing word games and almost like lacking any limited principle. Like if a court explicitly identifying relevant circumstances, or at least circumstances that, again, I think any reasonable person would say these are relevant, and then explicitly casting them aside to instead only look at a subset of the circumstances, a subset of the relevant circumstances in isolation, if that is the same as just not passing any judgment on completely irrelevant circumstances at all, then, like, how much of that can courts do before they're not doing totality of the circumstances analysis anymore, under Justice Jackson's understanding or like or standard or whatever? Like, could the DCCA just have ignored literally all four of the enumerated factors, all four of the enumerated circumstances, and just looked at one of them in isolation, and would that have been fine? Because Justice Jackson says, oh well, they're just ignoring irrelevant circumstances like courts do all the time. I thought that was what the totality of the circumstances analysis was explicitly not supposed to do, but I don't know. I think the other 7 justices were correct. I don't know about Sotomayor because I don't know what Sotomayor is thinking because she didn't say what she's thinking, so I don't know if she's right or not, or if I would agree with her or not, but I think I have been rambling on long enough, so if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you'd like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members get access to bonus and exclusive content and can request specific content, including other than reading Supreme Court opinions. So, with that, thank you for listening and tune in for the next episode where we will continue on through the Supreme Court's 2025 term. Until then.